just by way of introduction, I'm Ian Adderley. I work as a technical specialist at the Financial Conduct Authority in the mutuals registration function. The mutuals registration function is responsible for being the registering authority under the Co-operative and Community Benefit Societies Act. Some of you, it was previously the Financial Services Authority, and before that, the Registry of Friendly Societies. I think very briefly by saying we've called for and support the review that's been undertaken by the Law Commission. We think that modernised and up-to-date and supportive legislation is a good thing, and we're pleased to be engaging with the Law Commission and the co-op movement in the development of that review and the work that goes forward. And pleased to have been invited here to chair this session today as well. And my thanks to Co-ops and Mutuals Wales and to David and to Christopher for organising this. We've got two panellists today. We've got James Wright, the Policy and Development Lead at Cooperatives UK, who will be focusing on creating the conditions for cooperative growth. And then we've got Cliff Mills from Anthony Collins Solicitors, who will be setting out a bold vision for UK cooperation. We'll take those two speakers, do post questions in the chat, and I'll be looking at those. And then we've got plenty of time for questions after that from people like with the previous session. So with that, I will hand over to James.
Okay, thank you, Ian. It's nice to be on a panel with you and Cliff on a Saturday morning, I must say. When I was invited to join a Zoom call to talk about cooperative law reform on a Saturday morning, I thought, oh, of course, yes, this is exactly what people will want to spend their Saturday morning talking about. But then Cliff, kind of pointed out that maybe we should use law as the basis to have a more wide-ranging and potentially, dare I say, even more interesting conversation about how the law reform could be a springboard for economic transformation. So that's essentially what I'm going to talk about. It's a little bit about the Law Commission work, but you've already heard a lot about the great work that Nathan's doing, and then talk about some of the perhaps the broader implications as well. So I'm just going to share my screen because I do have a couple of slides, so please just bear with me. Okay, so I suppose the starting point, that's obviously Law Commission is reviewing the Cooperative and Community Benefit Societies Act, and that includes, a look at lots of interesting small technical areas around, audit thresholds and change orders mid-term, and the registration of charitable community benefit societies. Technical and niche, but in the things that's not really what I think it's about. For me, the starting point with this work is what are cooperatives, and how was society law created, and how has it evolved, and what is society law trying to facilitate that's different from other things in the economy? So for me, the starting point is around cooperatives, and I think by extension the types of community benefit society work with at Cooperatives UK. We're talking about a democratic enterprise with a mutual and a social purpose in some combination, and that the unique sense of this to doing business and organizing activity and organizing efforts in the world, the unique selling points are around sharing power and wealth through day-to-day business, and around being a enabler of collective action, different actors coming together, pooling their energies, pooling their resources to achieve more together than they'll be able to achieve on their own. And ultimately, the Law Commission review is attempting to provide better legal tools for people and communities and businesses in the UK to do those things. That's what it's really about. It's about do we have the right legal tools in the UK for sharing power and wealth through day-to-day business, collective action? Do we have the right tools for democratic enterprise with mutual and social purpose? So that's what it's about. It's obviously there are technical elements of that, but really we shouldn't lose sight of the picture. And I do think that whilst better law is not the be-all and end-all of creating the conditions for a thriving, impactful cooperative economy, it definitely could be. Having a world-leading cooperative legal framework could be a springboard for transformative approach to economic development, whether that's in terms of investments. So Nathan's already touched on the fact that that we are looking at share capital and capital raising as part of the Law Commission review. And I think when we're talking about creating legal legal tools for the types of investment and capital raising that cooperatives would like to do, more democratic, mutually beneficial investment. We're talking about enabling cooperatives, more capital intensive cooperatives perhaps to form and grow than is currently the case. We're talking about larger cooperatives being able to thrive and do more and have more impact than they currently have. And when we're talking about investment in what? Well, it's investment in housing, it's investment in sustainable food production, in renewable energy, green infrastructure, decarbonizing existing business, in harnessing the potential with for proven technologies in a way that is fair and democratic and good for the many rather than the few. I think it could make a massive difference. Like if you look at countries around the world where cooperatives are provided with really enabling tools in areas like capital raising, those cooperative economies are much more significant and impactful. So you look at somewhere like New Zealand or the Netherlands, where cooperatives do have a wider range of tools for capital raising and investment. The cooperative turnover there is equivalent to 18 to 20% of GDP in some years, whereas in the UK we're hovering more around combined cooperative turnover of around 2% of GDP. So I think it could make a really significant and transformative impact if we in the UK had some of the tools that are available elsewhere in the world. In terms of entrepreneurship, I think good law can make the cooperative option more appealing for different types of potential entrepreneur, social entrepreneur, mission-led entrepreneur, for communities coming together trying to do different things. And I think there are examples around the world where bring improvements to cooperative law seem to have coincided or preceded like a real growth in cooperative formations. I look at somewhere like South Korea, where they had a new cooperative law in 2012, and the formation rate of new cooperatives in South Korea is huge compared to what we've seen in the United Kingdom in recent years. In some years, they're 12 times greater cooperative formation than we see in the UK. So I think there are signs that like getting the law right can be one of the ingredients that makes a significant difference in people in terms of entrepreneurs and people trying to do things using cooperative models. I also see in countries where the cooperative law is really good, far greater use of like business to business cooperatives, that whether that's SME consortia, micro enterprise consortia, because business people can be more confident in using these models and these approaches because the law just makes sense to them. It's modern, it's enabling, it's not off-putting in the way that perhaps it sometimes is in this country at the moment. And if you look at things like public social partnerships where parts of particularly the local state in different parts of the world get involved with the social economy, with communities, with other businesses in a really cooperative way, sometimes through even formal cooperative structures. They can do that a lot more if the law is enabling and appealing and encouraging and modern. So I think whilst by no means is legal reform the be all and end all. It definitely could be a springboard for enabling some really transformative stuff in the UK. So I'm just going to finish law into a broader set of conditions for creating a thriving cooperative economy. So I've always talked on public cooperative partnerships, right? The ability for the state at different levels to partner with the cooperative sector to do things, whether that's in terms of commissioning and procurement, which has already been touched on today, but also in terms of things like industrial strategy, whether that's green industrial strategy or otherwise, or in terms of things like regeneration, like understanding how cooperative democratic can be used to deliver the objectives that government has. I think another key condition for a thriving cooperative sector is community power. The ability, the capability, the confidence, the opportunities for communities to come together and act together to do things, out of which cooperatives often form. Specialist business support is obviously really critical in terms of helping people set up and run successful cooperatives. A fair tax framework that recognizes the distinctive features of cooperatives, I think, can often be important, whether that's in terms of how cooperative surplus is treated, or perhaps in some cases incentives for people to invest private wealth in things that deliver broad social and cooperative goods. Enabling law is obviously part of it. Appropriate forms of capital, which I suppose is not just around the law, but it's also around making sure the state's enterprise investment schemes cater to the cooperative approach to raising capital. The work of things like the British Business Bank, etc., doesn't really do anything at the moment to support cooperative capital raising, but it probably should. And I think there are definitely some great things that already happen in Wales in this regard, particularly I think in relation to things like specialist business support and helping some of the types of appropriate capital find their way into cooperatives. So the great work, of Social Business Wales, I think does make a huge difference. Like Wales in recent years has the formation rate for cooperatives has led any other part of the United Kingdom. So it definitely does make a difference. We've done some analysis of where the hotspots for cooperative formation have been in the last 5 years. And in proportion to population, I think the top 4 like local areas are rural Wales, essentially. So there's something going on. There's something going on in Wales, which isn't necessarily going for the part of the United Kingdom. I do think some of these building blocks that are on this slide are in place here, and I think there's definitely more that could be done. I know there's talk about, for example, like a community rights legislation in Wales, which I think has the potential to be transformative. So I think ultimately enabling law could be really important, but only if we use it as a springboard to put in the building blocks for creating the conditions for cooperative growth that we need. I think I'll end there. Thank you.
Thank you, James. And exactly on time, and a perfect segue of that springboard to Cliff on a bold vision for UK cooperation.
Good morning, everybody. Thanks very much, Ian. Thanks, James. That was all very helpful. I can't think of anywhere I would rather spend on a Saturday morning than in Wales, even if it's virtually. So I'm very happy to be here and very happy to be joining in this discussion. So a bold vision for UK cooperation. Other countries around the globe have more developed cooperative economies than the UK. Why is this, and how can this Law Commission review help to change things? Cooperative development and growth in the UK over recent decades have not been the success story we might have hoped for. But with a climate emergency, a crisis of social inequality, and an economy founded on competition, there is a real need for a strong alternative form of business to investor ownership, one based on fairness, collective endeavour, and pursuit of the common good, one which redistributes power and helps to build democratic literacy. Something fundamental needs to change if cooperation is to become the force it should be in the country of its origins. And over the last 10 years or so, I've become increasingly aware of cooperative progress in other countries, and 2 areas in particular where the UK is different and needs to change. The first relates to the tendency to approach cooperative development by promoting structural change. This can be rather a distraction as it draws attention away from the key priority of an entirely different way of conducting business. A prominent feature of other jurisdictions, which we have lost sight of here, is commonly referred to overseas as a cooperative act, distinguishing it from what would otherwise be a normal market transaction. Let me explain. A cooperative act is what happens, say, in Buenos Aires, where a member buys something in their local cooperative store. Such a purchase is a transaction under the rules of the cooperative. It is not a normal market transaction governed by local contract law. This is a profound difference. Rules of a cooperative are essentially based on fairness, generally articulated through the ICA values and principles. Those values replace the usual competitive market arrangements, which can be unfair, exploitative, and usually for somebody else's benefit. Removing the competing interests between buyers and sellers was exactly what the Rochdale pioneers achieved 180 years ago. Their solution in legal terms was to replace the unfair adversarial market system involving a shop selling to customers with an approach where the customers were the shop. buying collectively and selling back to themselves individually at a fair price. And this fair price was achieved through the dividend, which was an ex post facto price adjustment. Cooperation replaces competition in this approach to get to the best for everyone in need. Open membership, anybody can participate. All of this was set out in the rules of the cooperative, the formal document that recorded how members agree to conduct their affairs together. Cooperative law replaces contract law. In today's context, such an approach requires a co-op to keep two sets of accounts. One for transactions with members, where no private profit is derived, and one for transaction with non-members, which are not governed by the cooperative rules, but by normal market rules, i.e. contract law. These two types of transactions are different in nature, one being predicated on fairness with nobody making any personal gain, the other on market principles governed by the profit motive and private benefit. The Rochdale pioneers eliminated the consumer contract from retail sales. Mondragon achieved a similar objective in employment. The workers themselves are the business, so there is no binary relationship or employment contract between the business and its workers, just the rules of the cooperative. So the radical discovery by the pioneers wasn't a clever legal structure, it was a different method of trading, what the Victorians referred to as the Rochdale method. This approach, based on collaboration for everyone's benefit rather than competition for private gain, is the foundation of a cooperative economy and demonstrates how cooperative trade differs from open market trade, why it encourages community wealth building, builds democratic literacy and civic engagement. This is the cooperative difference. We don't need to change the law to revive the Rochdale method in the UK. Law isn't the barrier, just lack of understanding. But we do need to change the law if we want the Rochdale method and a cooperative approach to be recognised and encouraged as an alternative method of trading. And this brings us to the second area of difference with the UK. The second area where the UK differs from other countries is that our law does not define cooperative. There is no clear legal cooperative identity which policymakers can use to encourage trading for a social rather than a private economic purpose. This matters because where governments see the growth of a cooperative economy as one of the ways of addressing today's biggest challenges, they need a clear legal identity. The UK has this for charities, but not for co-ops. We need a clear legal definition to enable cooperatives to be used as a policy tool for addressing today's crises of climate and social inequality. Countries with some of the strongest cooperative economies not only define cooperative in their laws, but also refer to cooperatives in their national constitution as a specific form of enterprise that they recognise separately from investor ownership. This ensures that when legislating, they consider a diversity of enterprise approaches. It also means that where they want to encourage regenerative and distributive rather than extractive and degenerative businesses, they have the means to do so. The UK, of course, has no written constitution, but that doesn't mean that laws cannot be passed that guide future lawmaking. The Wellbeing of Future Generations Act in Wales is an example, placing on public bodies, including Welsh ministers, a duty to ensure that in their actions, the needs of the present are met without compromising the ability of future generations to meet their own needs. For me, this is a quasi-constitutional provision and capable of influencing not just future lawmaking, but the types of business that are set up and encouraged by government. Government at all levels needs mechanisms by which it can make a difference in terms of addressing the climate emergency for future generations and challenging the unfair distribution of opportunity, which is blighting so many lives today. The type, shape, and fundamental purpose of different types of business are a factor here. So to conclude, we have a choice to make. If we're serious about cooperative growth, within the movement, we need to choose cooperation instead of competition. And to enable cooperation to grow, it needs its own clear definition and identity. There is a need for clarity for those setting up new businesses, clarity as to how and why the features of cooperation provide a clear framework for meeting people's current needs and establishing a sustainable business, and clarity for policymakers seeking to address our biggest needs, clarity about the benefits which cooperative enterprise brings to communities, regions, and future generations. There are other important matters to be addressed by the Law Commission review, including the provisions relating to share capital, as has already been mentioned, a generic protection against demutualization, and a thorough overhaul of outdated legislation to make it fit for purpose for the standards expected for an area of corporate law today. We at Anthony Collins are publishing a series of briefing notes for the purposes of this Law Commission review to raise awareness and encourage conversation, particularly in sectors that could benefit from reform. Sector-based briefing notes are already available for the care sector and local government. I'll post them in the chat in a minute. Others will follow, including utilities, banking, and housing. And they're all available on the ICA Law Committee's website. There's also, at the very beginning of the chat, I put a link to a review of UK cooperative law, its first 100 years, if you like, which the Cooperative Heritage Trust have just republished. So that's all from me. I think I'll leave it at that. Thanks very much.